Hello again, this is Bob Weir with another interview of people in the news in North Texas. My guest today is Judge Brody Shanklin, who presides over the 211th District Court in Denton County. Judge Shanklin is here to talk about the County Drug Court that was approved by Denton County Commissioners in October of 2016. Thank you for being here, Judge Shanklin.
Thank you for having me, Mr. Weir.
Now, if you would just tell our viewers the purpose of the drug court.
All right. Well, this drug court is the first actual drug court that has been set up in Denton County for that specific purpose. The drug court is designed to treat high-risk felony offenders that really show a genuine interest in breaking the cycle of addiction. And so the purpose of the program is to take individuals, mostly individuals that are already on felony probation, that keep basically failing that probation period. They get revoked either for committing new offenses or for testing positive for drugs. And so this is a program where we try to integrate intensive treatment into their lives rather than just sending them back to prison, so that they can try and actually break that cycle of addiction.
And how often does it convene?
All right, we meet the second and fourth Thursdays of each month. So we convene twice a month. The actual court itself, where the participants come into the 211th District Courtroom, court convenes at 4 o'clock.
Right.
But prior to that, the drug court team, which consists of myself, Judge Burgess, it consists of Scott Weisenbaker, who runs a nonprofit, Solutions of North Texas, which does a lot of inpatient therapy. We have a counselor, Robin Watts is a counselor. We have a volunteer defense attorney that's on the team, Caroline Simone. We have 2 district attorneys that are assigned to the district from the district attorney's office. And we have Kevin Edwards from probation, who actually handles the caseload. So that drug court team meets at 3 o'clock in my court, in the jury room, in order to discuss all of the current participants plus the new applicants that are coming in.
Is participation in the program voluntary?
Absolutely. We do not force anyone to sign up for or participate in drug court. That is an affirmative action on their part, where it's a fairly lengthy application process and screening process to even come into drug court. Keep in mind, Mr. Weir, this is, with these high-risk felony offenders, this is usually their last chance before they go to prison. So there's some incentive to stay out of prison, and hopefully what we try to make them realize is it's not only to stay out of prison, but it's to break that addiction cycle.
Judge, at what point did they ask for participation in the program?
Okay. They can ask for participation in the program while they're currently on probation. Let me give you an example. If an individual has already been sentenced to probation, they're on felony probation, and let's say they have been failing several drug tests, that issue can come up, and prior to a revocation being filed, that is a legal document that is filed that would go to court saying, Judge, we want you to revoke their probation because of X, Y, and Z. Then at that point, the probation officer or their defense attorney can refer that to the district attorney's office and say, we believe this individual has a major addiction to drugs, and we would like to refer this to drug court, and then an application packet is given to that individual.
And if they do participate in the program, how long is it?
If they're accepted into the program, the average length of the program is between 19 and 24 months long.
Oh, I understand that 85 to 95% of addicted prisoners relapse upon release.
It is a staggering percentage. Because it's simply, by nature of an individual going to prison, yes, they are going to be sober while they're in prison.
Sure.
Because they're not using drugs. But if they never receive the proper treatment or therapy or counseling, when they get out, they're likely just to go back and start using drugs and reoffend again. And so, yes, it is a very staggering figure on the amount of people that relapse and end up going back.
Another staggering figure is that the average cost to supervise someone on probation is $3.40 a day, while the cost to house someone in a state prison is $57.79 per day.
Well, you can imagine.
So I can imagine this would save a whole lot of money if you could keep people from coming back. Okay. It's a recidivism program.
Absolutely.
Really. And the treatment is limited to high-risk felony offenders?
Yes, sir. As of right now, because of the limited funding that we have for the court, we have a maximum participation of 20 individuals. And so we're capped at 20. Now, when people graduate out of the program, we can accept other individuals into the program. And so we have to be fairly selective about these high-risk offenders. We have to turn people away all the time that apply, and they may apply because this is their last chance. They may end up going to prison over a revocation case because they failed probation, but if it's shown through the paperwork that they do not have an addiction to drugs, they do not get in the program. And so we do have to be fairly selective.
So they have to be, number one, high-risk felony offender who abuse drugs and they want to quit drugs.
That is correct.
All right. But what is the screening process like?
Okay. Screening process is fairly intensive. They fill out, again, a fairly lengthy informational packet that has all their name, their biographical information. It will, once it gets to the DA's office, they'll have their criminal history all pulled up because obviously there's a screening process. There's certain offenses that we can't take. And then we really look for, even if it's not a drug charge that they're charged with, let's just say they're charged with repeated theft cases, but it's shown through the paperwork that the thefts are occurring because the person is addicted to drugs and is using the money from the thefts to buy drugs. That's part of that screening process to identify these individuals. So the screening process is, once that's identified, then that packet is given to the individual. Through their attorney, they turn that packet back into the district attorney's office. The district attorney's office reviews their application, makes sure that it goes through our initial qualifications, and then once it meets the qualifications, then that information goes to our probation office. Once it goes to the probation office, Mr. Edwards puts all the information together on this individual, and then when we convene for drug court in our drug court team meeting, we all discuss the individual and then vote as to whether or not they're selected for the program.
All right, so they're out in the public and they have to prove that they have to prove to the court that they didn't go back to drugs.
They could go back to drugs, but what they have to show is that there is a drug problem, but that they're willing to break that cycle of addiction and they're willing to accept
And
that.
how do you know that they broke the cycle?
Well, because they test positive for drugs. That may be one of the main reasons that they are even subject to having their probation revoked anyway, is continued positive test under their
All right, I understand that any participant can be tested anytime.
That is
for
correct.
drugs or alcohol.
It's a minimum of twice a week.
Okay.
At least in our first phase. But if there's suspicion, even when they come to court, if we believe somebody has come to court and they're under the influence, they can be tested immediately. Believe it or not, we've only been in session since October, but we have sent people to jail and to treatment facilities directly from court for showing up intoxicated.
Really? All right. So then there are 4 phases to this program. You want tell us what those are?
Sure. We first start out with stabilization. I mean, the very first thing that has to happen for an individual to succeed in the program is they have to get stabilized. They have to get clean.
Right.
Sometimes that's a jail stay. They can be sentenced to a short term of jail to assure us that they're off of drugs, because we don't want any bleed over from the past drug use to come into court. So stabilization is key. So they have to show that they are stabilized, and we can do that by getting them sober. That doesn't mean that it's easy to keep them sober, but stabilization is key. The follow-up to that is, second, is intensive treatment. And so that intensive treatment, depending on their level and what they're addicted to, could include intensive inpatient treatment, meaning going to a facility to receive treatment for that drug addiction. After that intensive treatment, then it's transition. So that transition would be transition out of intensive treatment. They're still going to their support group meetings, NA, AA, still going to some counseling sessions, but that's not the intensive area. And then transition and aftercare are the last 2 phases. That's to show us that they can maintain their sobriety and that they can break the cycle while not being in intensive supervision.
What type of sanctions are imposed for non-compliance?
All right. Non-compliance can be anything as severe as having their probation revoked and going to prison. It can be spending a weekend in jail, or it could be a judicial admonishment, and there's lots of ranges that we have, but the most severe is prison.
Well, Judge, this sounds like a great program, and it helps to keep people out of the prisons, and And I think it's a fabulous service that you provide. So I want to thank you for being here and for all of your service to the justice system. Thank you so much,
Thank
sir.
you so much for having me. I greatly enjoyed it.
My pleasure, and thank you for watching.